However, targeting those with an underlying alcohol problem that makes them more likely to consistently drive while impaired remains an important issue. And more than half of convicted DUI drivers continue to drive on a suspended license, and only a small fraction of DUI episodes ever result in an arrest. This bill will create a 24/7 sobriety program designed to give jurisdictions which wish to participate another mechanism to address DUI recidivism. The bill authorizes a court to order a person convicted of multiple DUIs to successfully complete a qualified 24/7 sobriety monitoring program. This idea began as a model program in South Dakota in 2005, requiring those convicted of alcohol-related offenses to take twice-a-day breathalyzer tests. It is now a statewide program in South Dakota, North Dakota, Montana, with pilot programs in several other states. They've been studied. This type of program has been studied, and evidence strongly suggests they work at reducing DUI arrests. Importantly, Congress approved the FAST Act, which provides grant money to states that implement such programs. So I think this bill, this specific legal authority contained in my bill, opens the door for some federal funding to support this type of program, which is why it's better than just leaving it to the discretion of courts to experiment. We can pull down some federal funds. And here to testify today is Dr. Gregory Majette of the RAND Corporation in Santa Monica. So Dr. Majette.
Thank you very much. And good morning, Chairman Jones Sawyer. I'm Greg Majette. I'm an associate policy researcher at the RAND Corporation. We're a nonpartisan, nonprofit research organization. And I'm honored to be here today to share our research findings about 24/7 sobriety programs around the U.S. I think it's very important to discuss new approaches to combating drug and alcohol-involved crime. At RAND, I've conducted research on 24/7 sobriety for more than 5 years. I've studied the program's efficacy, conducted field observations, and learned from the people operating the program in various states throughout the country how it's run. There are three core necessary components of 24/7 sobriety programs. First is the ability to order individuals to abstain from alcohol. Second is frequent alcohol testing by breathalyzers or another technology. And third is swift, certain, but very modest sanctions for a violation. From 2005 to 2015, 30,000 people have enrolled in the program in South Dakota, and they accumulated more than 5 million days without a detected alcohol violation. These are among repeat DUI offenders and other people with convictions for alcohol-related crimes. About half of participants violate while they're on the program, and they serve between 12 and 24 hours typically in jail, but multiple failures are less common. Of the nearly 8.5 million breathalyzer tests ordered over this period, 99% were clean and completed. And after counties adopted the program in South Dakota, the total number of arrests for repeat drunk driving fell by 12% at the county level, and domestic violence offenses fell by 9%.
Can we hold there and let Mr. Lovell speak, and then if there's additional questions, the committee? Thank you, Doctor.
My name is John Lovell, and I'm here on behalf of the California College and University Police Chiefs, Association of LA Deputy Sheriffs, the California Narcotic Officers Association, LA County Professional Peace Officers, LA Police Protective League, and the Riverside Sheriff's Association. We are all strongly in support of this bill. This is a smart strategy. It works. It reduces DUI offenses, and it also has the side benefit for some people who have an addiction to alcohol problem of being that first path towards sobriety. What I'm about to say, I have permission to say. My wife is a recovering alcoholic. This Monday, she will have 31 years of sobriety. I had her look at this bill and do some research, and she told me, she said, honey, if this had been around way back when, I would have had a lot more than 31 years.
Very good. Thank you, John.
Thank you. Are there any other, before we start, we now have a quorum, so go ahead and Madam Secretary.
Of course. Jones Sawyer.
Here.
Melendez. Lackey. Here. Lopez. Lowe. Quirk. Santiago. Quorum is present.
Okay, thank you. And you have one more witness, 2 minutes or less.
Mr. Chairman, members, Mark Weideman on behalf of Intoximeters, a company that has been in business over 70 years in preventing DUI recidivism. And Intoximeters has worked in other states, including South Dakota, on the programs they've had there and has seen remarkable success, and we're here to support the bill. Thank you.
Thank you. And are there anybody in support of the bill that would come up and say your name and your organization? Good. Are there any questions from any committee members? Do we have opposition? Oh, I'm sorry. Do we have any opposition? I apologize. Do you have any opposition to the bill? Going once, going twice. Okay. No opposition. Are there any questions from any of the committee members? Yes. Ms. Melendez.
Thank you, Mr. Chairman. Assemblyman Cooley, I apologize, but I don't see, is there a length of this program identified within the bill?
I think it creates an authorization for the court to impose it, and
so I'm just wondering, could the court impose it for a month, 10 years? Is there any limit or minimum, maximum?
no, let me
speak to what
okay.
So traditionally, it's up to the some combination of the presiding judge, a probation officer, other court officers, and the attorneys to decide the length of time based on the risk characteristics of the individual placed on the program. The median time, the typical time on the program is around 30 days. I'm sorry, around 90 days in South Dakota, though it can vary greatly depending on the individual. So it's.
Well, I think it can vary greatly depending on the judge, not the individual necessarily, but the state and the.
I apologize.
Type of person who's hearing their
It's at the
case.
judge's will for the length of time on the program.
Sure. Is there any intent to make any changes in this bill to identify minimum, maximum amount of time?
I think typically it's 90 to 120 days. It's not stated in the bill, and I'd be very happy to work on some reasonable boundaries. I think the issue, what we're trying to address is formalizing some powers for the courts to have this additional arrow in their quiver to deal with repeat offenders, serious repeat offenders. And I think it would be in the powers of a judge under our civil system today to kind of fashion an appropriate remedy. So I will say, this is the first hearing. I would be very open to trying to think what would be an appropriate sort of boundary to put on it.
So can I ask, because there's already in place the ability for court-ordered, the ignition lock system.
Right.
So can I ask why we would add another layer?
What I was saying, Melissa, Madam Melendez, is there is federal funding available to support these programs, and a